doing in this terrible weather that we've got. Thanks for making the effort. It's a real pleasure to have you all with us today at Garden Court for this joint event with the LCCSA and Garden Court Chambers. It's the first event in the new premises, so we're really happy to be here today, and thank you very much for joining us. Thank you to everyone online as well. So this training is brought to you by Garden Court Chambers, the Community Crime Team, and the London Criminal Court Solicitors Association. My name is Casey Jenkins. I'm the current president of the London Criminal Court Solicitors Association. So in terms of what we're covering today, this training event will cover practical guidance on making urgent applications for a writ for habeas corpus to ensure the release of clients unlawfully detained in custody. The topics our speakers will cover include issues when considering whether to make an out-of-hours application to the High Court, the procedure for making such applications, recent case law in this area, and then legal aid and other costs considerations. There'll be an opportunity at the end of the session, like I say, to engage in a Q&A session, so please do feel free to make notes as you go along and we can come back to some questions. So to introduce our speakers, we have Will Hanson, who is a barrister at Garden Court Chambers. Will specialises in criminal defence, immigration and associated public law challenges. He's an experienced trial advocate with a broad practice in general crime, financial crime and extradition. He also has a particular expertise in cases engaging human rights issues, including modern slavery, public order and protest. We have Bartholomew Dalton, who is a criminal defence solicitor with expertise across all stages of the criminal justice process. He is at Hickman Rose. He's the Law Reform Officer for the London Criminal Court Solicitors Association and also the co-author of the Blackstone's Magistrates Court Handbook. He also contributes to the Criminal Law Week's Commentary Board. In July of this year, he was appointed as a solicitor member to the Criminal Procedure Rules Committee. So these two brilliant lawyers are extremely well placed to guide us through how to challenge the unlawful detention of our clients. I'll hand over now to Will to just kick off the session.
Thank you, Casey. Well, good evening, everyone, and thank you so much for making it through the rain to our first event at our new chambers. It's really good to see you all. Firstly, we have no PowerPoint slides, but we do have a detailed note which will cover everything and more that we're going to discuss today. So please don't feel like you need to take notes during the talk. Holly and I hope that this will be quite a practical guide to considering and making habeas corpus applications. Habeas corpus touches on a number of areas of criminal law, but the most common is when, I'm sure all of us are familiar with this, our clients end up stuck in custody when they should be released. That might be after sentence, it might be when they've been acquitted, and you expect them to be sent up from the cells, but actually they're on the bus back to whatever prison it is. And we're going to look in some detail at practically and legally what you do in that situation. I expect you'll want to hear about two things in particular. The first is really what you need to do from the start of that process through to when you go and make your application, often out of hours, to the High Court. And also what the funding position is in those situations, which is reasonably complex. And fortunately, Tolly is our expert on that issue. And helpfully, I'm not going to talk about either of those issues. I'm going to set the scene by looking at what habeas corpus is and when not to make habeas applications, as well as looking at a couple of the key cases in this area. And these set out helpful principles which you can deploy against the prison when you're trying to ensure the release of your client. So firstly, what is habeas corpus? It's Latin for you may have the body. Essentially, it is a writ which requires a detained person to be brought before the court so the legality of their detention can be examined. And it's often rather romantically linked to the Magna Carta and it being an ancient safeguard of liberty, but more prosaically, it's being described quite recently by the Supreme Court as a speedy and effective remedy in cases of unlawful detention. If an individual is detained unlawfully, then issuing a writ of habeas corpus can compel their immediate release. Now, habeas corpus's most famous moment came in 1772 in Somerset's case, Somerset was a slave who was captured and imprisoned on a ship lying on the Thames. A writ of habeas corpus was issued requiring him to be brought before the court and the cause of his detention explained. The ship's master said that slavery was authorised by the laws of Virginia and Jamaica, and that Somerset had been detained so that he might be taken over to Jamaica and sold there. And in ordering Somerset's release, Lord Mansfield quite famously said, "Slavery is so odious that nothing can be suffered to support it but positive law. I cannot say this case is allowed or approved by the law of England, and therefore Somerset must be discharged." His counsel perhaps had the best line, though, when he said, "The air of England is too pure for a slave to breathe in." So that might be something for your bail applications. So what are the core principles of habeas corpus? It's a writ of right, not of course. What does that mean? Well, unlike in claims for a judicial review, the remedy in habeas corpus is not discretionary. Where the application is made out, the writ must be granted. And importantly, and we'll come onto this a bit later, once the unlawfulness of an individual's detention is established or the lawfulness is challenged, the burden is on the detaining authority to justify the detention to the court. So when you go and say to the prison, "My client's unlawfully detained," they can't say, "Well, prove it." It's for them then to show that they are lawfully detained. So the burden is on them. There is no time limit to bringing a habeas corpus application. In practice, we are looking at situations which are probably going to be pretty urgent, often overnight. And one of the great advantages of this remedy is it has priority over all court business. So it'll be the first thing the court will prioritise if an application is made. When do you use this remedy? When do you want to invoke it? Well, most straightforwardly, it's when there's been an order for someone's release from detention and they've not been released. That's straightforwardly the sort of narrow way in which habeas corpus applications tend to be made. And it can get a bit confusing because it can be used in other contexts, but you have to be quite careful because habeas corpus application is not to be used as a means of challenging court order. So if the court has said they must be detained, then the proper way to challenge that is by judicial review. It is challenging the person holding the individual in detention, not a court order putting someone in detention. And also, it may be unnecessary in situations where you have a straightforward right of appeal against someone being detained. So, for example, in the magistrate's court, after a bail hearing, someone will be detained and you can apply the Crown Court to challenge that, appeal it. But you still can make a habeas corpus application, and often you might want to consider it because it is quick. When you appeal other decisions, it can take a long time, but the court will immediately consider your application if you make a habeas application. So I'm just going to take you through a couple of recent cases. And these two cases, well, Tolly's going to talk about a third, which is also relevant, but these two really are the bedrock of recent principles when it comes to habeas applications against prisons. And they show how awful the prisons often are at engaging with you and how they have not got the proper procedures in place most of the time, and they don't really take it very seriously. And they also show how the judges are taking it very seriously. So the principles which come out of the case I'm about to go through should, and we'll come on to this in a bit, really be used against the prisons. They should be cited back to them when you're trying to get your client out of custody, because the court have made some pretty serious and adverse comments against prisons, particularly Wandsworth, it appears. So the first case is Nyagwi, against the governor of HMP Wandsworth, Mr. Nyagri was acquitted by Westminster Magistrates Court of 2 charges of breaching the notification requirements of an SSO at 7 p.m. on a Friday, 2022. And he was informed by one of the justices that he'd be processed and released within 30 minutes. The Serco staff informed Mr. Nyagri and his advocate that he'd have to wait until the following Monday to be released. I should say he was sentenced on the Friday evening, as the offender management unit at Wandsworth would not be available until then. He applied for a writ of habeas corpus, and in response, the prison said, well, we can't do anything about it. You have to wait until Monday. There was an initial hearing before Mr. Justice Chamberlain, and that hearing was adjourned to Monday so more information could be gathered. And in the event, Mr. Nyagri was released shortly before the hearing on Monday, so the application was not pursued. However, the court was invited to impose costs against the prison, which were granted on a standard basis. And in his judgment, Justice Chamberlain said there are a number of troubling features of this case. The first is that no person, including a Serco employee, a police custody officer, prison officer, governor, anyone else, may detain another person except with lawful authority. The second is that a person who complains of unlawful detention does not have to show that there is no authority to detain him. That's a point I made a bit earlier. And he said this is not just a procedural quirk, it is central to the protection accorded by the common law to the liberty of a subject. And he said the question for the prison should have been, can we show there is legal authority to detain? Not, can we show that someone has authorised a prisoner's release? And that's something which you'll hear from prisons when you say, our client should be released. They'll say, well, no, he needs to be processed. But that's not a justification. Just because the prison haven't managed to process your client, it doesn't mean that they remain lawfully detained in their custody. Third, Mr. Justice Chamberlain said, the need to comply with prison service instructions and policies prior to release is not a lawful ground for detention. And so, again, often you're going to have invoked, oh, we need to go through the procedures, we have a particular policy for this is how it's done. The offender management unit needs to check out all these things before someone's released. And they clock off at 5 p.m. and say, sorry, you have to wait until Monday. That is not a justification, and you must make it known to the prison that it's not. Mr. Justice Chamberlain has said so. Fourth, a complaint by a solicitor that a prisoner is being unlawfully detained demands a substantive response as a matter of urgency, even over a weekend, and it's not acceptable to say, wait until Monday. And I certainly, in my experience of dealing with prisons and making these applications, almost invariably have just received a level of, disinterest, can't get hold of anyone senior. I think the problem is often that people who work in prisons don't really see the problem. They think, well, what's a few more days? They've been in custody for however long, And so they don't take it as seriously as they should. The next case is the case which really made Tolly famous. And it's Kim versus the governor of Wandsworth. Mr. Kim pleaded guilty to an offence of battery. He was sentenced to 10 weeks imprisonment, and as a result of having spent time already, he should have been released immediately after sentence. However, he was instead taken back to Wandsworth and was told it might take 2 days for his paperwork to be completed. So Tolly complained to the prison that the detention was unlawful, but he was unable, I believe, to speak to the deputy governor. Bartholomew, I apologise, I don't know who Tolly is. Bartholomew.
For those that don't know, I'm Bartholomew, but I'm also called Swallow.
That's a very good question.
I said Bartholomew.
Mr. Dalton complained to the prison that the detention was unlawful, but was unable to speak to anyone, to the governor, and he received no response to his emails, which he marked as urgent. And so an out-of-hours application was made and granted by the High Court at around 2:30 a.m. the following morning, and it demanded that Mr. Kim was produced at the RCJ at 11 a.m. that morning. Should he not be released before then? He wasn't released before then, and nor did any representative from Wandsworth attend the hearing. He was eventually released after having been detained for over 23 hours, but the judge went on to make an order requiring the governor to explain why she had failed to comply with the writ. And the governor failed to comply with this as well. So a further order was made in the same terms, endorsed a penal notice, and eventually the governor responded, conceding that the prison had messed up completely and he had been unlawfully detained. And in his judgment, Mr. Justice Pepperell endorsed the principles set out in Niagwe, but he further emphasised that it's not lawful, it's not acceptable to detain prisoners for a further 24 hours after there ceases to be any lawful basis for their detention. And it's incumbent on the prison service to ensure that pre-release checks are done speedily. The onus is always on them to establish that there are grounds for further detention, and it's not upon the prisoner to establish his or her entitlement to release. And he also emphasises that prisons must be able to respond urgently to lawyers requesting the release of their clients. They need proper processes in place, people after hours who can deal with these problems, not just the offender management unit who apparently always clock off at 5 p.m. And really it goes a bit further than Niagwe in underlining how important it is to engage urgently with these issues. Also, when communications are received out of hours, as will often be the case with applications, they should be passed to the duty governor for further consideration, instead of being met with, in his words, institutional indifference. And the judge stopped short, I believe, of finding the governor in contempt of court in that case. But he did observe that, taken together, these matters evidence an unacceptably lax and disrespectful attitude to compliance with court orders, and he formally declared that Mr. Kim's detention was unlawful and ordered costs against the prison on an indemnity basis, which is the most punitive basis on which costs can be awarded. So if you have a case against Wandsworth, then you're on pretty firm ground if they're not behaving properly or responding as you want them to, and you might want to be citing, well, you stopped just short of finding the governor in contempt before, but if you don't get your act together, then that might be a possible outcome next time. I'm going to let Holly discuss further case, because I'm not quite sure why, but you seem to like it more than I did.
I like this case. It adds a few helpful lines to conversations with prisons. It doesn't add much in terms of the law, but I think it's illustrative. It's useful as an illustration of the way in which prisons have historically or recently treated applications for writs of habeas corpus. Similar to him, the detainee, and I want you to bear this in mind, the detainee wasn't released on time. The prison, which was Pentonville, failed to comply with the writ for habeas corpus, as was the case with him, and released the detainee after the writ had expired, or the deadline within the writ had expired. Again, they were ordered to provide a statement to the court explaining why it had happened, failed to provide a statement to the court. It was then listed for the prison to attend and explain. Rather than the governor attending, the head of OMU turned up, and the head of OMU turned up with an email, printed email, that said, "To whom it may concern," and bearing in mind this is rather than the statement that they'd been ordered to provide, a load of irrelevant here. "Given the release was transacted yesterday, I would say that the process worked as expected. However, always keen to receive feedback in ways we can improve. Simon Drysdale, governing governor." He was promptly required to attend in person, and I think grovel immensely before the High Court. One is left wondering and we'll come on to this, I think, perhaps right at the end, given the history, NAGWI had already happened, what does a governor have to do to be in contempt of court? Kim, I think there were 3 orders ignored in total, including the writ. Bashir, another 3 ordered, and still no contempt. But a question, panel. Sadly, I'm aware of at least one more case since those 3 cases. It's not a published judgment, but I think the solicitor in that case might be on the video link, I'm not sure. I think that case postdates all of these cases. And my understanding of that case, it was Feltham. It was another weekend case. Solicitor phoned up, explained that the detainee should have been released and that his partner was due to give birth the next day, not released until the next day after a writ for habeas corpus had been obtained. But during the attempts on the Friday night, notwithstanding Kim, notwithstanding the Adby, notwithstanding Bashir, the prison officer that spoke to the solicitor's comments was something along the lines, I understand, of, sorry, nothing we can do, but at least your boy will get some compo. And I'm afraid that is the reality. Even post these judgments, prisons are still not taking these problems seriously. Moving on to what to do if you find yourself in a situation where your client hasn't been detained, and the handout is detailed. We've tried to do it as effectively almost a checklist, so you don't need to make notes as we go along. Every criminal solicitor's favourite thing, the civil procedure rules. Part 87 deals with them. They're actually quite readable for civil procedure rules and relatively straightforward. However, what the civil procedure rules don't tell you what to do is the steps that you need to make with the prison before you get your out of hours application past the out of hours duty clock in the High Court. So firstly, you need to phone the prison. We all know how to do that. Go on the Find a Prison webpage, .gov webpage. Numbers are there. Make a good contemporaneous note of everything that is said. Often prison officers say quite unhelpful things that look good in a statement and then get parroted back in judgment. It also makes your life a lot easier. If you've got a really good contemporaneous note, you can just cut and paste it into your statement that you're probably drafting late at night, so it makes your life easier. Be prepared, as Mr. Justice Beckel said in Kim, for institutional indifference, and as was said in Bashir, to be fobbed off. You need to insist to speak to the duty governor. The prison officer that you speak to will almost certainly tell you that's not possible. Really helpful lines. Will's already gone through them, and we've put a little kind of list that you can parrot back to prison officers when they refuse to put you through to the governor. So it's not acceptable to wait until X time, X date from the AGWI. It's extraordinary that a solicitor's insistence that someone is being detained unlawfully doesn't meet the threshold of seriousness to trouble the duty governor. Kim, prisons must be able to respond urgently to lawyers properly raising questions as to the lawfulness of continued detention. Not acceptable to ignore habeas corpus applications or regard them as an inconvenience against Kim. And again, communications from solicitors about prisoners' release and assertions of unlawful detention should not be fobbed off or blocked. When they are received out of hours, they must be passed on to the duty governor ASAP. In NIAGWI, as a result of NIAGWI, the HMPPS set up a support line to help prisons where there were suspected cases of habeas corpus. No one at Wandsworth seemed to be aware of that in relation to Kim, so helpful to draw it to their attention. Although a word of warning, at the time the Kim decision was published, that helpline closed at 10 o'clock. So get a look on that. If they won't put you through to the duty governor, insist on them providing a name and an email address, and then follow up the call with written representations in an email as well. I have been told, I don't know whether it's true, that to get past the duty clerk, you need to have made at least 2 phone calls to the prison and been rebuffed on both. If your client's still not released, And as part of those suggestions to the prison that they should be releasing your client, I think you should be making it very clear that you will be making a habeas corpus application, you will be applying for costs against the prison, and you will be applying for damages in due course as well. But if they still don't do that, then you need to complete the High Court out of hours form, and we'll put a link to that form in the notes, and then you send that to the duty clerk. And the email address is in the handout as well. In order to make an application for habeas corpus, you would normally need to submit a claim form under Criminal Procedural Part 8 and a witness statement, but in urgent cases, and I think this is always likely to apply in an out-of-hours habeas corpus case, the judge can dispense with the requirement that a claim form be filled immediately. And also, you should be asking for permission to serve any writ by email, assuming it's granted. The witness statement that must accompany the out-of-hours, or should accompany the out-of-hours application form, ordinarily would be made by the detained person according to the criminal procedure rules, unless they're unable to. And obviously in any out-of-hours habeas corpus application, they are going to be unable to provide a witness statement. So it will be you, the solicitor, that will need to draft that statement. And you will need to provide confirmation that the application is made at the insistence of the person being detained. So you are going to need instructions from them, which can be difficult in these cases, particularly as access to phones in prisons can sometimes be problematic. There's then a typo on the note. It says the nature of the destination, which is hopefully a one-way ticket out of prison. It should actually say the nature of the detention. Fairly straightforward. Why were they detained? Why should they be released? And also I would suggest what efforts you've made to encourage the prison to release them, and then confirmation of why the person's unable to make a witness statement. Potentially also, particularly given it's a duty judge, it might be helpful to draft a short skeleton argument which includes the relevant case law, but not essential and no requirement to do so. If you don't get a response from the duty clerk, there's a number to call the admin court out of hours. Again, the number is on the handout. Speak to security and ask them to speak to your duty clerk. I'm sorry, for those that are online, we should have said at the start, we will email the handout as well. So those that aren't here in person will be penalised. The application can be made without notice, but the court may direct you to put the applicant on notice. In reality, that's going to be the GLD, Government Legal Department, who are acting for the prison, and we've included the out of hours contact details as well. In my experience, you leave a message and they come back to you fairly quickly. The out of hours judge will then review the claim and then may either determine the matters on the papers, which was the case in Kim, or hold a telephone hearing, which I think was the case in your.
Yes.
Yeah. In the majority of cases, the application will be adjourned and a writ will only be granted where there is no possible satisfactory response to the application. If a judge dismisses the paper application, you can request that the decision be reconsidered at a hearing. In terms of the adjourned hearing, if there are disputed factual questions, they will usually be decided on the basis of an affidavit, evidence, or witness statement. Note the difference as criminal lawyers. The well-named governor of Wandsworth, Katie Price, in my case, got told off because she submitted a witness statement and not an affidavit. That was yet another breach to add to her list of breaches. If the application is granted, you'll need to serve the writ on the duty governor ASAP, and normally the writ should be served in person, so a process server, but an out-of-hours judge is likely to direct service by email. Then hopefully you've got your writ for habeas corpus, now you've served it on the prison, and hopefully your client is then released. Notwithstanding that, the next day, regardless of whether your application is successful or not, you need to file a claim form and pay the relevant fee, which at the moment is £123. I've spent about 40 minutes trying to work that out today, so I've saved you the trouble if you have the situation before it goes up again. Thereafter, the judge will probably make directions in terms of submission of costs and required cost schedules potentially, and also there may be directions in relation to whether there'll be proceedings for unlawful imprisonment and damages. which would usually be brought in a separate claim in the county court, but the High Court does have the authority to transfer proceedings. I think one thing that as criminal lawyers we have to be very, very careful about is that unlike compliance with the criminal procedure rules, which can be fairly lax and relaxed, the High Court are absolute sticklers for compliance with the civil procedure rules. There are various fees for applications, so if you are applying to extend a deadline, you need to pay the fee and make the relevant application. In my case, Wandsworth got in a lot of trouble because they didn't comply with the civil procedure rules on various points. And then finally, depending on what has happened, the prison is likely to be required to provide either a witness statement or an affidavit, or in particularly court cases of misconduct, required to attend court to explain why the detainee was detained unlawfully.
Just a couple further points. I think it's quite a good idea when you're corresponding with the prison to set a deadline for when you're going to make the application.
They'll ignore it.
They'll ignore it, but don't make it wholly unreasonable, but say, you know, by this time, it will be unreasonable for you not to have at least properly justified your position. And quite often, I expect they won't have done. So you need to sort of make yourself look reasonable in the eyes of the court, while also going hard on the prison, and not just pulling the trigger immediately on a habeas corpus application. You know, technically they are unlawfully detained, but it's going to hold much better favour with the court if you've given them a chance to rectify the issue. And so putting in a deadline helps. I don't know how many of you...
Sorry, can I just interject on that point? I think the other real advantage of setting deadlines is that when you've got a client who's been detained unlawfully, you will know that you are very, very likely to have very distraught family members who are very, very upset that their beloved hasn't been released. And I think if you set deadlines for the prison, it's quite a good way of managing expectations in terms of your dealings with the family members.
And the only other point I had was, you may be instructing a barrister to do the actual hearing, but you don't need to. And actually, in my experience, I did this for the first time at some point, didn't really know process, but the out of hours duty clerk is, in my experience, very helpful, and will just tell you what they need and exactly how to do it. But you don't need to do a skeleton, as Polly said, and you just send the cases. If you don't want to do a skeleton or you don't have time, the court's going to be aware of the case law. But the really important thing, the thing which will win or lose your application, is this trail of correspondence as set out in a witness statement. You just document everything methodically and to show how unreasonable this prison is being. Beyond that, you don't really need further documents to justify your application. It might help to have a short skeleton argument. And a telephone hearing, I had one with Mr. Justice Saini at 3 a.m. and it was very short, and he just sort of nothing really. Yeah, he wasn't particularly happy. I thought he might be friendlier to me, but he wasn't.
What time in the morning?
3 in the morning.
Have your answer there.
Yeah.
Not used to the out of hours police station.
But he was angry at them.
Not a duty solicitor.
He was angry at them, and it wasn't a complicated hearing, because all it is just setting out the evidence you've gathered in a few hours before. So don't be afraid to take these on yourselves if you're struggling to find a barrister.
One caveat to that, and I don't know the answer, is I assume you would need civil coverings.
Yes, that's a good point. Do be afraid to take these on yourself. You might be disbarred.
And tired and exhausted.
But if you do have civil high rights, yeah.
We've dealt with appeals very briefly in the handout. I'm not going to talk about them now. It's very unlikely that you'll be dealing with an appeal kind of at short notice, so you're likely to have time to look that up. Moving on to the next bit, which is, I think, one of the most difficult things for criminal solicitors, is legal aid. And I was fortunate, I was privately instructed in Kim in the criminal proceedings and remained privately instructed in the habeas corpus proceedings. Civil legal aid is available for habeas corpus. And I should say it was very generous of Will to describe me as an expert in civil legal aid. I am absolutely not, but I am very grateful to my civil team who have been bombarded with questions late last night and this morning and have very patiently answered my annoying correspondence. Civil legal aid is available. However, this can also be done as associated civil work under a criminal legal aid contract. And in order to do it under a standard crime contract, the habeas corpus proceedings must arise from a matter or case within the crime category of law. I've set out provisions in the handout in terms of the various civil legal aid regulations. I hope I never have to look at them again. I haven't spent 3 hours with them last night. But there is essentially a means merits test. There is a legal aid calculator that tells you whether your client is financially eligible or not. Again, link in the handout. And the legal aid agency, perhaps having been inundated, though there aren't very many of these cases, with criminal solicitors getting it wrong, have very helpfully provided training material specifically on making applications for legal aid in relation to habeas corpus proceedings as associated civil work. So there clearly are problems that they felt the need to address. Normally, if you have access to CCMS, you do it via the portal. Obviously, that's not available at the moment.
Don't have the portal.
Legal aid issues. You can still complete what is called a CID App 1 and the appropriate CID means form and email it to the address in the handout. Alternatively, you can also apply for emergency legal aid using the CID App 6. And I think the big difference looking at the forms last night, the CID means form for a normal application would have to be, the financial part would have to be completed by your client, signed by your client. The emergency application, you are signing so that your client has told you the information. Email it, and my civil colleagues tell me that often legal aid, emergency legal aid can be granted within 24 hours. There is no ability under a standard crime contract to delegate authority. I've had mixed messages on civil, where if you have a civil contract, whether you can delegate legal aid yourself, i.e. grant legal aid. Someone has said you can because they did it in a case recently. My civil colleagues don't think you can. So I don't know is the answer to that. But where legal aid is granted, legal aid can be backdated, provided that urgent work had to be undertaken immediately or at short notice, and that the application for legal aid was made at the first opportunity. So that's legal aid. In terms of costs, important to bear in mind, again, as criminal lawyers, that if you are unsuccessful in making an application for habeas corpus, there is a risk that the claimant may be liable for the defendant's costs. So important to consider merits carefully before applying. Although I think in the majority of the cases that we've talked about today, and probably the majority of cases you will encounter in practice, it's fairly straightforward. But the court has warned that there may be considerable cost consequences as a result of frivolous applications, and there are a couple of examples. One thing to bear in mind in terms of legally aided litigants, they have cost protections in relation to the defendant's costs, which means that although the cost award can be made against them, in the event of an unsuccessful application, it wouldn't be enforced without the leave of court. And where you have a client who is impecunious in practice, I understand the orders are rarely enforced. Hopefully, though, you are successful. If you are successful, you can apply for your costs from the defendant, i.e. the prison, and where you are on legal aid, this can be done at commercial rates, and obviously if you are acting on a private basis, then it's whatever your rates are as agreed with the client. You will also need to consider whether to apply for your costs on an indemnity basis. Two options in civil law for cost: standard and indemnity. I'm not going to go into the ins and outs. If you've got to that stage, hopefully you've got counsel who knows what they're doing. Speak to Will. Or don't, based on that face. In terms of the difference in costs, in order for indemnity costs to be awarded, the defendant or the other party has to have acted in a way that is unreasonable to a high degree. It's interesting, case law in terms of habeas corpus is mixed. NIAG was standard, we were in indemnity, and I think we were only indemnity because the prison had failed to comply with so many orders, including the writ. I think if it had just been the habeas corpus and they'd complied with it, I don't think we'd have got our costs on an indemnity basis.
I'll just jump in there and say we got indemnity costs in an application I made without there being multiple breaches of court orders. You should always threaten it, and if they've just not provided any good reason for failing to engage sensibly, then there is a good chance that the court will consider that a good case for indemnity costs.
Interestingly, there's no mention in here, so I don't know what was said in relation to that. In practical terms, the difference between indemnity and standard costs is that if you are awarded costs on a standard basis, you are likely to get a reduction to your cost, probably 20 to 30%, but sometimes more. If it is on an indemnity basis, you're likely to get your full costs with maybe a little reduction. So that's it in terms of costs. Again, the references are set out in full in the handover. And then I think we both had a couple of issues, or a few issues, that people might want to consider in terms of either making applications or just moving forward generally in relation to contempt. So firstly, a side issue, and it was an issue that my client was slightly worried about, is publicity. You may have a client who has flown under the radar in terms of press publicity, and if he's then or she is unlawfully detained and you apply for a writ of habeas corpus, you could well get a published judgment that could be picked up in the press. A couple of them have been. I know that we have talked about it in relation to at least one high-profile case, and the client decided that he'd rather have a day extra or 2 days extra in prison than further increase the risk that his detention became known to the public. And then also contempt. What does a prison governor have to do to be in contempt of court? How many orders do they have to breach before there's some actual recompense beyond adverse publicity and costs?
Yeah, my sense on that is, if there are other instances like Nyagwi and Kim, especially against Wandsworth, I think the court's going to come down pretty hard on them next time, because then if there's been no change, even though there's been some serious comments made by the court, then I think they're going to lose patience, and that would be a really positive thing in terms of hopefully encouraging prisons to engage better with these issues, put proper policies in place. And it is a reason why, in my view, even though it's the last thing you probably want to be doing, especially if it's a Friday, as it often is, trying to get your client out of prison, possibly going to court late at night, you know, it's not going to change unless courts, prisons are being challenged in the courts, and the courts have been pretty robust so far. And possibly it'd be good to see a contempt case.
Yeah.
Interesting, at least.
Yeah, interesting, yeah.
And presumably, if there were to be contempt proceedings against a governor, it would make the rest of the prison establishment take notice in a way that doesn't necessarily, you would have thought it would, but it doesn't necessarily seem to have happened. One, I think, very live question, we're all aware of Westminster, I think, are particularly bad at this. You have a client who is sentenced or acquitted or whatever, and there are then huge delays before they are released because the prison service, the court, whoever it is, are processing the paperwork. at what point does that delay become, well, at what point is that delay unlawful? Nagui and Bashir have both made comments suggesting that some time may be appropriate for the prison service to facilitate or sort the paperwork out, although both make noises that where possible release dates, etc., should be sorted out, possible licence conditions should be sorted out before the detainee is taken to court. There isn't a clear answer, and it's one of those things that I think clearly, what the courts have said is that overnight is not acceptable, over a weekend isn't acceptable, but within a day, the court hasn't said what is acceptable. There may be some potential application there, but I think there is a risk that bad law could be created on the wrong case. I don't know whether you have any.
Yeah, it's a question of judgment, and there isn't going to be a case, I expect, that says you have to do it within this amount of time. It will depend on the prisoner, and it will depend on the procedures in place at the prison. What has been made absolutely clear is it should be done pretty quickly, and if the onus is on the prison to have everything in place to anticipating someone's release so that they can be released as soon as possible. But you want to be mindful, again, of just rushing into something. If the prison have said, oh, we need more time to release them, we're processing the paperwork, and you're thinking, oh, here we go again. You do need to, in my view, allow enough time so that if you do pull the trigger, it's a reasonable time to do so, and we don't have a time for you. Certainly, because if someone's released in the morning and then they're not let out of prison, how long do you wait? Do you wait to the end of the day? It depends on the case, depends on the responses you're getting from the prison. But clearly, a court is going to say, I expect, they need a bit of time to get this sorted. Yeah. So I think you just got to build in that scope for showing that you've given it a reasonable time and they still haven't complied.
Mr. Justice Ritchie was clearly alive to the issue, and Bashir, but kind of ducked the issue, saying that he'd not heard argument on it. At the end of his last two sentences in his judgment are a call for guidance, official guidance, to be produced to fill the gap. I can't imagine HMPP, whatever they are, SS, have taken any note of that, but I'm not aware of any new guidance in relation to that.
No. Finally, does your client want to pursue a claim in damages for unlawful imprisonment? That's beyond the scope of this talk, and it's most likely something that the civil team will be dealing with. But again, it depends on whether it's worth it for the client, whether they're going to get much money from it, how long they've been unlawfully detained. But it's more pressure on the prisons, it's more of a disincentive for them to behave in the way they have again. And so that's something you should be advising your clients on when all this is over. Is it something they want to pursue separately?
And I think if you have a strong judgment from the High Court in relation to the habeas corpus proceedings, it makes it a lot easier in terms of negotiating with DLD in relation to damages and trying to get your client exemplary damages. So in Kim, my several colleagues and I were able to get damages that weren't far off what would have been awarded if the court had awarded exemplary damages, which was just short of £10,000 for 23 hours custody. And I think having that strong judgment really puts you on the front foot in terms of negotiations with GLD.
That's it.
Any questions?
So just a comment really, from what your experience are, despite these court judgments, the prison service still hasn't got procedures in place to deal with these applications out of hours. They're all saying, oh, you've got to come back Monday when they're sitting. And they're not even sort of acted to get a sort of out of hours procedure in there, which would help.
Well, it depends on the prison, I guess. I haven't had experience with every prison. the ones which I have dealt with, it does seem to be the case that there hasn't been some concerted effort to sort this issue out. And I don't think it crops up enough for them for it to be something that they're like, we have to deal with this right now. You know, they're under-resourced, they're understaffed, they're underpaid.
I mean, what's particularly concerning is that the first of the trio of cases, and they agree, Mr. Justice Chamberlain says, taken together, the governor's statements taken together provide little reassurance that these events will not be repeated. And here we are.
Yeah.
These cases keep happening.
And then Kim happened.
And then Kim happens,
So,
and then Bashir happens, and then the Felton one happens, and I think there's at least another as well.
It's something that has been raised on the London Criminal Justice Board, isn't it?
LCCSA has had various run-ins with various prisons, and I would read your emails with interest. So,
Lots of run-ins, so it's something that's being raised in the background, the point being made that in the long run, it will save costs, which is a language that the MOJ are
no, I appreciate
receptive
you
to.
doing all the work there, but no, I'm sorry, it's just a comment. I mean, thank you for their input, really useful, good stuff, you know.
I mean,
But just,
there's
just practical difficulties at the other end, isn't it, really?
Mr. Kim cost the taxpayer 25 grand plus whatever their costs were, and yet lessons still haven't been learned.
Can I ask a question? I for one am looking forward to my next Friday sentence. Very exciting prospect, because they will fuck it up, you can be absolutely sure. But it's just a practical question. How do you engage with the opposition? Otherwise, so there's a form that you fill in for making the application, but can that be ex parte?
Yeah.
Do you have to automatically inform the governor that you're doing it?
So it can be ex parte. In reality, in my experience, the out-of-hours clerk under the directions of the judge will tell you to make contact with GLD, and the number for GLD is in here. It's also on GLD's website.
The
Government Legal Department.
Within GLD, think it's a privately run prison?
Good question, don't know the answer.
I'm tried.
you'd have to ask me that.
I suspect it would,
Yeah.
but I don't know.
Can I ask, another question? If background damages, it seems really high, considering that I think that there are cases where people have sued where, for example, their sentence calculation has been wrong, and they get threatened halfpenny per day because they're considered to be unmeritorious people. But is the 10 grand because of habeas corpus or because of your client?
So it's because it's exemplary. There's a huge difference between standard and exemplary. Don't quote me. I think the standard that is about 3,000. Problem is, all these cases are old. There's various gifting authorities, and inflation has to be factored in. You obviously get a higher. I say obviously. I'm not sure it is. You get a higher rate for your first day in detention, and then it tails down.
And that's directly connected to the wrongdoing in the prison.
Yeah.
So if you've made contact with them and they've just not responded appropriately, that's going to increase your
So
chances.
exactly what we want, and there's a sliding scale depending on the circumstances rather than something standard.
Yeah. I mean,
paltry sum.
so in Kim, they effectively they accepted exemplary with a slight reduction for litigation risk. It was.
Yes.
Is there any sort of movement, especially in the judgments that you referenced, to stiffer penalties either against the individuals, in particular the duty governor, who will frequently refuse to pick up the call, having been in that situation fairly recently, but also to stiffer financial penalties, because 10 grand might be a lot in a general civil context, but the budget for Wandsworth is about 35 million a year. And so 10 grand is about what it costs them to replace a door if there's a bad thing.
Yeah.
I think there is an increase in the sense that contempt was very openly talked about in Kim. Bashir, the governor, was made to attend court and clearly grovelled a lot and was effectively let off on the, so that reading between the lines, was let off on the basis of their grovelling. Whether, of course, prepared to go further, I don't know.
This might be a slightly elementary question, but is there a way to sort of calculate how much costs you should apply for after the end of it in terms of civil for wrongful imprisonment? Insofar as, is there like a particular scale or guidance if your client's been in detention for over 72 hours?
I'm not an expert by any means, but there's case law setting out, and Mark was referring to it earlier, there's case law with various scenarios setting out what the court at some point has thought is appropriate in cases that have gone to trial. And it's trying to work out how your case fits within that often slightly contradictory set of cases that aren't particularly recent.
Okay, thank you.
So there's no...
So there's no central, okay.
Matt?
We've had a few situations recently where clients have been released, and once we've got to the bottom of it, the fault actually lies with the courts and they've accepted the wrong paperwork. Would it change the way you do it at all? Obviously, it doesn't make the detention lawful, it just means the fault is the courts, not the prisons, but would it still be the same process?
It would be the same process. It doesn't change the analysis from a habeas corpus perspective. It would change the analysis probably in a civil claim.
I think it would, because I think the prison would try and deny liability and say the court should be liable.
But just because it's not actually the prison's fault that someone's unlawfully detained, it's not a justification for them still being detained. So yes, it can be and often is the court's fault. In fact, I had one horrible case once where it was a street homeless client, and he had a bail application. Bail was granted, and then we didn't hear from him again. Got to trial, just assumed that he wasn't going to turn up, wasn't there, and then the court clerk says, "Oh, your client's in the cells downstairs." And I thought, that's a bit odd, but maybe he's here for something else, I don't know. I went down, and he didn't realise he got bail 3 months ago. And the court had never communicated that to the prison. He hadn't tried to communicate with my solicitors. And so everyone just thought he was out and had just sort of done a runner. I had to tell him this. And it was awful, because I was like, you shouldn't be here right now, come on, let's get you. This is all unlawful. And I said to him, you're going to have a great claim, it's a great civil claim. And he said, he's not got any money. And I said, look, you're going to get some money from this at least. And he just said, I'm not interested, and walked off. But yeah, that was, it does happen. And it's as simply as a court error, as you say.
I've also had the adverse in terms of clients. Nat knows him well. Client that had a lot of burglary cases ongoing at any one point. Prisons would inevitably struggle to work out what he was serving, what he was on bail for, what he was on remand for, and was quite frequently detained unlawfully. And he would phone me up and go, Bob, I need you to make up a fuss. They fucked it up. I don't want to be released because I want compo. But you've got to make it seem like I want to be released. So lots of angry phone calls explaining how distressed he was, but no substantive action. And then pass it on to, as TV Edwards' civil team in those days, to deal with the compensation claims against the prison.
Sorry, it's a comment as well, rather than a question, but I imagine the number of applications is increasing as the prison unfortunately descends into chaos. Is that right?
I think, I mean,
Makes sense.
there weren't many cases that I'm aware of kind of pre-NAGWI, and then you have this flurry, which maybe the prison is getting worse, but I think there's also an increased awareness in the defence community in terms of what steps to take.
Yeah, and also in some cases you won't hear about. I did a case which wasn't reported, so it was a successful habeas case, but there are probably quite a few of those which, so we don't know, but I expect Bartholomew was right about there being an increase because people know more about it and how it shouldn't happen.
The courts also try and avoid listing sentences on Friday.
Yeah, okay. I didn't know that.
I think there's some sort of listing policy chat in the background about that.
Can't see that.
Yeah. Well, thank you to you both for...
One more question.
I don't know if this would be appropriate, but I've had a few cases recently where the delays in the court have meant that someone on remand hasn't been sentenced when they should have been. There's been a repeated adjournment despite bail applications being made. Things just kept being pushed for weeks on end. Is there ever a point where that can itself become unlawful, or would that be more difficult to argue?
Well, that's a question of bail. And bail is a funny one when it comes to habeas corpus, because ultimately it's a court decision whether or not to grant someone bail or not. And generally speaking, though it's not always the case, that's a matter in the Crown Court for judicial review, or in the Magistrates Court goes up to the Crown Court. However, the Criminal Justice Act, I think it's section 17 of the 2003 Act, expressly preserves the right to make a habeas corpus application in respect of bail. So you could, in theory, invoke it if you think you're not getting any traction with the court in a situation like that, but you might be at risk of being criticised for doing so.
I think my feeling is you're likely to get very short shrift.
Yeah.
There is an alternative remedy, JR, and I think there is a risk that you could be looking at adverse cost consequences if you're unsuccessful. Can you explain the difference between the cost that can be imposed as I had a successful application and was not clear on what to ask for recosts? If you're privately funded, very straightforward. You ask for the cost that your client has incurred. If you're on legal aid, I think you claim on an hourly basis, but not my strong point. You may want to speak to a civil lawyer. So the question is, can you do it with higher criminal higher rights? My feeling is civil proceedings under the civil procedure rules. So I don't know is the honest answer.
I'm afraid I don't know either, clearly, given my previous comments. They're probably in a situation where it's urgent and you've already got high rights in a criminal court. I doubt the judge is going to take the point against you.
Yeah.
But strictly speaking, you shouldn't really be appearing if you've not got civil high rights.
I think at that time, in that situation, the judge is probably grateful to it.
Yeah, exactly.
I assume the application fee isn't covered by legal aid, or can you claim it as a disbursement?
So it's on the handout, sorry, we didn't reflect that at all. It is possible to apply for a fee waiver, and there's a separate form, and the link to that form is on the handout. You can also obtain court fees in relation as disbursements on legal aid.
It'd be easier to do it that way.
My civil team kind of said you do what suits and whatever is quickest, but you think it's going to be quickest and easiest. Are direct instructions from client absolutely necessary? Good question, and I appreciate the difficulties. The civil procedure rules are clear that there should be. Funding wise, I think you also run into difficulties if you don't have instructions.
That goes into Mark's question about overcoming the barriers to communication with your client and getting instructions to proceed.
And I think maybe where you're speaking to your client in custody and they're due for release, maybe it's good practice. We should be telling our clients that if they're not released, they need to make a fuss until they're allowed to speak to us.
It's deemed as reasonable prior to making the application. I think that was dealt with by Will in terms of lining up and setting up what is.
Yeah, I mean, it's just, there's no easy answer to that question. It's a question of judgment.
And I think you've got to appreciate that in the prison there is a chain of communication. Unless you get the direct email address for the governor, it's likely to be going through a conduit. So giving them 10 minutes, 20 minutes isn't likely to be reasonable.
I think in terms of the instructions point, it is very difficult. It's just a bit of a catch-22, and often you won't be able to get through to your client. You ask the prison. If you haven't managed to speak to them about it prior to them being transferred back to the prison, then you do have a bit of an issue. But if it's the case that they wanted to be released after whatever it was, and you were quite clear about that, then I think it's, in my view, that would be enough from which to say I have at least implicit instructions to try and get him out of custody.
Hi, given that the person who's unlawfully detained is in prison, and I'm guessing the answer is no, but have there been any cases of litigants in person who have been unrepresented and have made these types of applications?
Not that I'm aware of.
There have been in relation to general habeas corpus cases.
Oh, yes, in the Supreme Court.
Yeah, I've also been approached on behalf of defendants or detainees who wanted to run them, and I said that I wasn't able to act, and I think probably a lot of solicitors had said they weren't able to act on the basis there was absolutely no merit to their applications. So those people are, I think, applying as litigants in person. In relation to these types, I'm not aware of any.
In fact, you're right, there is a case which we've set out in some detail because it's a recent Supreme Court case dealing with habeas corpus and just general principles, but it is a litigant in person who went all the way up to the Supreme Court. Is that right?
Yeah, my experience of habeas corpus, because it links back to Magna Carta, there are some fairly kooky conspiracy theory views about habeas corpus. Freemen of the land, it's that kind of territory.
Yeah.
Sometimes.
But that was in a family context, not in a criminal context. I don't know about any in a criminal context.
Thank you, a huge thank you to Garden Court for hosting this event tonight, especially to Luke and Anusha and the entire events team. And a special thank you also to our training officers, Claire Bostock and Anna Jemison, and our training subcommittee for all of their contributions to arranging this event. We are arranging more events, we'll be in touch, and we hope to see you at the future events as well. Thank you for coming.